Hi, everyone. My name is Samir Varma. I'm a partner in Thompson Hine's International Trade Group. Welcome to today's SmarTrade webinar. This is the second in our series of 5 SmarTrade fundamentals webinars that we're doing over the next several weeks. The first one was on economic sanctions, which was 2 weeks ago. For today, and if you didn't get a chance to log in and hear that one, feel free to shoot us an email and we can maybe send that over to you. But for today, we will be examining export controls, including export requirements and procedures, and we're going to try to highlight some compliance issues for exporters of U.S. products. Before we begin, I do have a couple housekeeping items. As you may have heard, today's program is being recorded. We will send a link to all attendees within 48 to 72 hours of today's presentation. We'll also send along the PowerPoint to all attendees after the presentation, so you don't have to take notes furiously. You will be getting the presentation. Quick disclaimer, this presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates, Thompson Hine, etc. The content should not be taken as legal advice, as the views expressed are for informational purposes only. Now, if you do have any questions during the webinar, please feel free to use the chat box located in the control panel on the right side of your screen to submit questions. I would ask that you send questions either directly to me or to the panelists in general instead of the entire chat room. We will answer as many of the questions as we can, both during the presentation and at the end of the webinar. And if we don't get to your questions, we'll follow up after the program by email or phone. Finally, CLE credit for today's webinar is pending. Please be sure to complete the verification of attendance survey. The link to the survey will be posted in the chat. We'll also paste this link at the end of the program. I will announce the attendance tracking code at the end of the program for you to use for your purposes. Today I am joined, and so why don't we get started actually, but so today, if you want to go to the next slide, Aaron, I am joined by my colleague, Aaron Mandelbaum, an associate in our international trade group. Aaron will be taking the lead on today's discussion. I hope he's not too sad after the Phillies lost yesterday. I hope he can get through the presentation. And we'll just have to see, but please be patient with him if he does mess up, because I think that's still weighing on his mind. Thank you all for your interest, and we'll go ahead and get started.
All right. Well, thank you for that introduction. I really appreciate the reminder about my Phillies too. Thank you. But as Samir noted, my name is Aaron Mandelbaum. I am an associate in the International Trade Practice Group here at Thompson Hine. We actually have a lot of ground to cover today, so we're just going to get right started by going through this agenda quickly to see. We're going to talk about what export controls are and why countries impose them in the first place. And then for the bulk of this presentation, we're really going to focus on a very simple yet extremely complex question of, can I export this? And as we'll see, based on the regulatory regime that we're looking at, that multi-step process does have some variation. Afterwards, we'll then turn to some red flags that an export transaction may pose, and then we'll turn to penalties. And then finally, we'll conclude with recent trends, which I think is really important, because in addition to providing you with some fluency in the basics of US export controls, by kind of highlighting a few recent trends, you can kind of see what's currently driving the conversation among practitioners today. So with that, I think a natural question then is, okay, well, why should I care, right? How exactly do export controls impact me or my business? It's a great segue to the next slide. And I don't think anything that you're seeing is particularly surprising, right? Of course, export controls can cause supply chain disruptions. They can result in major financial penalties or other restrictions, can certainly include reputational harm. I think what makes export controls so tricky is just the pace in which they're rolled out. I would describe it as a fast pace. I'm sure many people in this call would say, are you crazy? It's more like frantic. But the point is we are seeing export controls rolled out on a near weekly basis, and they're really significant. They can curtail business opportunities with certain foreign markets, and they can open up transactions to government scrutiny by regulators, which is just a horrifying sentence in the English language for many businesses out there. And it certainly doesn't help that a lot of the items controlled for export purposes is an increasingly growing list. The number of industries designated as critical to national security is constantly expanding. And finally, uh, as we're seeing, export controls are increasingly rolled out on a multilateral level. So what this demonstrates is export controls impact you and your business quite intimately and quite extensively. So with that, we're just going to go into actually asking ourselves, what exactly are export controls? And for that, we've got this definition for you. Export controls refer to the laws and regulations and rules regulating the export, re-export, and transfer of goods, software, and technology, collectively what we refer to as items, based on the end destination, the end user, and the end use of the item. Now, what we're going to do is we're actually going to spend a significant portion of this presentation breaking this down clause by clause, because as we'll see, this simple, straightforward question is actually pretty complex and layered, packaged and layered with complexity. So what we want to do is before we actually break it down clause by clause, let's just take a brief step back and just simply ask ourselves, why do countries impose export controls in the first place? And the answer to that question is that they are necessary tools of economic statecraft. Export controls are economic countermeasures in response to geopolitical events, and they're considered ideal for protecting national security interests and promoting foreign policy priorities. However, export controls are just one tool in this toolbox, and I've highlighted just a few of the other tools in this toolbox for your consideration. So for example, a foreign investment review. So if you're familiar with the Committee on Foreign Investment in the United States, that's what that is. Supply chain rules. So that would be, for example, the Uyghur Forced Labor Prevention Act, arguably our trade remedy laws as well. But I do quickly, before we move on, I do want to highlight economic sanctions because they are often confused with export controls, especially amongst beginners. And I just want to kind of really highlight, Samir mentioned that was the first session of this webinar series. And by all means, check it out. I think it's on YouTube now if you need a refresher. But really the focus with economic sanctions is the question there is about who and who you cannot transact with or deal with. They're really focused on, transacting with foreign governments, industries, certain malign actors, whereas export controls are really focused on the movement of goods and technology and software. So it's really about the movement of items. So that's the key difference. Now, let's return to our definition. And like I said,
Aaron, one sec, if you can jump back, I just also want to highlight that I think you're absolutely right. Economic sanctions is more transaction based, while export controls is really like goods based, and that's really important here. There's a lot of crossover between the two items. One thing that we're doing with the SmarTrade Fundamental Series, Aaron, you mentioned that we did economic sanctions before. We are doing the supply chain and other customs and Uyghur Forced Labor Act and other sort of issues in our later SmarTrade Fundamental Series. But this one today, we're really just focusing on export controls.
Yes. Yeah. So along those lines, let's actually return to our definition. And to get a better appreciation and understanding of export controls, like I said, we're going to now break this down clause by clause. A little bit of a disclaimer. We're not going to go perfectly sequentially. We're going to try our best, but we're not going to be perfect. So apologies in advance. But let's begin. Let's break this down. And let's start at the very beginning, which is the laws and regulations. And we'll start with the laws. Now, there are two primary export control laws. There's the Arms Export Control Act and the Export Administration Act of 1979. The first is the implementing statute of the International Traffic in Arms Regulations, and the second is the implementing statute of the Export Administration Regulations. Don't worry, we will kind of explain what that is in greater detail momentarily. But what I really want to kind of focus on from this slide is to note that while these are the primary export control laws, The truth is that export controls are mostly espoused at, or predominantly, I should say, espoused at the regulatory level. So with that, let's look at export control regulations. And as you can see on the screen, this is not a comprehensive list of export control regulations. There are many different regimes governed by various agencies. So this is actually just a handful of them that I found online that kind of came to mind quickly. But this is by no means all of them. But we really just want to focus on two in particular for today's conversation. The first is the Export Administration Regulations, and the second is the International Traffic in Arms Regulations. So now, oh, sorry.
Yeah, before you jump ahead, we do have a question about the recent Loper-Bright decision, which is the Chevron deference, which impacted sort of not only these regulations, but you and I understand that it's a landmark. It was a big decision by the Supreme Court just this past June, basically changing judicial deference to the agencies that enforce these federal regulations. It's just a question about sort of how this could impact export controls and going forward.
Yeah, that's a phenomenal question. Yes, this was a landmark decision by the Supreme Court. It certainly really kind of challenges the judicial deference that courts would extend to the federal agencies that make and administer regulations, including export control regulations. In terms of their impact on export controls, as we just discussed, export controls are these tools of economic statecraft. They're predicated on foreign policy priorities and national security interests. So I would be kind of surprised if there were challenges to the export control regulations invoking Loper-Bright that were successful in the short term. I would imagine, if anything, under kind of the umbrella of international trade law, that it's the more stereotypical commercial trade laws. So, for example, customs regulations and trade remedy regulations that are probably going to be subject to challenges invoking Loper-Bright first. So that's my caveat to all of this is short term, I just don't see much of a change in the export control regulations.
I think that's right, but I think that even with customs and trade remedies and other areas, there's so much of it is predicated on these national security concerns that are really the purview of other sort of aspects of the government as well, that it's hard to see too much going on in the short term. Long term, I think, it's up for grabs. We'll just have to see.
It's a very different story long term for sure. So now that we know kind of what export controls are, why they're implemented in the first place, and where they come from, let's get really to the bulk of this presentation, which is, again, this very simple but challenging question: can I export this? And of course, that's going to naturally beg the question, well, what is this, right? And as we can see in our definition, kind of staring right back at us, it is the goods, software, and technology, collectively what we are referring to as items. And when we ask ourselves, can I export this item? What we're actually doing is we are engaging on a multi-step process to figure out if we can really export something to ensure that we're complying with US export controls. Now, I've identified those 7 questions for you on the screen. Rest assured, we are going to now just basically break it down question by question. So let's start at the very beginning. What exactly is it that you're exporting? Yes, we know that it is going to be a good, a service, a software, or technology, but we want to ask ourselves kind of, how else can we look at it? In other words, what type of item is it? And when you talk about US export controls, there are 2 primary types of items. There are military items, so think defense articles and defense services, which don't worry, we will define in a moment. And then there are also what's called dual use items. These are items with commercial and military or nuclear proliferation application. So think for the first kind of group of items, think kind of like Defense Department, the Pentagon. With the second, think more of like civilian items, but on second thought, maybe they could be repurposed for a military want or need. And that's really important because it feeds into our second question, which, if you recall, is who has jurisdiction? And the question really is what agency has jurisdiction over the item? Jurisdiction just being this very fancy legal word meaning who has the ability to administer and enforce regulations over the item. And when we talk about U.S. export controls, there are two primary agencies that do so. The first is the International Traffic in Arms Regulations, or ITAR, which is administered and enforced by the Directorate of Defense Trade Controls, or DDTC, within the State Department. And the second is the Export Administration Regulations, the EAR, which regulates dual-use items. And that's administered and enforced by BIS, the Bureau of Industry and Security, within the Commerce Department. And what's helpful is, when you engage in this analysis, no matter what regulatory regime you're looking at, you're pretty much going to ask yourself these 7 questions every time, which makes life a lot easier. I should note, though, that because the ITAR is going to regulate over specifically defense articles and services, it's a more kind of exclusive group of items that it's concerned with. This analysis can be curtailed slightly. You still want to ask yourself these questions, but DDTC is more focused on, once they know that they have jurisdiction, great. Do you need a license? We don't necessarily really care that much about where you're sending your item, who's going to receive it, and what it's going to be used for. Of course, that's going to be factored in the analysis, but ultimately it's a kind of shortened process of, okay, we've got jurisdiction. Do you need a license or not?
I just quickly jump in here. That's absolutely right, and I do want to say, obviously, we're oversimplifying a lot of this for purposes of this webinar. But the reality, and I think you're absolutely right. The way often we look at this analysis is we look at whether or not ITAR has jurisdiction, or DDTC or ITAR has jurisdiction over the products, the transactions, etc. Once we determine that it doesn't have jurisdiction, automatically everything else is subject to the EAR, or under the EAR analysis. And also, I mean, we definitely end up skipping more steps simply because ITAR is more restrictive and it's sort of a licensing regime for every country in the world rather than some of the things that you'll get into. But under ITAR, there are also considerations related to where are you exporting, because there are a list of prohibited destinations, that you can't get a license even if you tried, right? There's areas of the world that we have a national security interest in making sure that ITAR or U.S. controlled defense articles are not getting to. And so it does make the analysis a little bit simpler, simply because it's so much more restrictive, right?
Yeah, absolutely. And I think since we keep talking about, what exactly is within the scope of ITAR, let's turn to that very issue, or as we might say, what is subject to the ITAR. And as this first bullet point simply kind of reminds us, it's going to be a narrower class of items. So it's always important that you want to start your export control analysis with the ITAR before you move to the EAR. And I think actually we should pause really quickly to really highlight when we talk about whether an item is subject to the ITAR or the EAR, it's mutually exclusive. In other words, it's either or, but not both. You can't have an item that is going to be subject to the ITAR and the EAR. So with that in mind, let's talk about what is actually covered by the ITAR. Now, the first are what's called defense articles. These are items or technical data on the U.S. munitions list, or USML. More on that in just a bit. But I also want to point out the ITAR also covers defense services. So this is furnishing assistance to foreign persons for items related to items on the USML. And I don't think there's a wide variety of activities, but I don't think any of them are super surprising. I've included just a few on the screen. So for example, the design, the repair, the operation, etc. Of these items. And then finally, the ITAR also covers technical data. This is information necessary for, a variety of activities, the design, the manufacture, the repair of items on the USML. So think like, formulations, bills of materials, blueprints, photographs, you get the idea. Now, that is what the ITAR covers. And I want to talk about its classification system, the USML, how it's actually devised. And as we can see, there are 21 different categories on the USML where you will find defense articles and services. I don't think any of this is super surprising. Firearms, I always joke about vessels of war because it's literally in the name, directed energy weapons. But I want to point out that sometimes you might have an item and you don't think it neatly fits into any of these categories, including category 21, this kind of miscellaneous category. And when in doubt, you can actually always just ask DDTC to classify your item for you by submitting what's called a commodity jurisdiction request. And this is a process that we here at Thompson Hine are super familiar with. So this is a kind of a great way to emphasize that not only will we be more than happy to assist, but also there are clearly definitely ways to make sure that you are properly classifying your item. Now, I do want to note that there are two significant quirks to the ITAR system as a whole. The first is this concept of registration. You do need to register with ITAR because of the sensitive items that you're kind of manufacturing or exporting or brokering, defense articles, services, and technical data for. Registration, it's actually not super complicated though. You're basically going to tell DDTC who you are, information about your company, like its ownership structure, affiliates, subsidiaries. So that's pretty much registration. You do have to pay an annual fee, so just bear that in mind too. But the second quirk is objectively the quirkier of the two. It's what's called the see-through rule. And this rule is so quirky, it's actually not even in the ITAR. It is an unwritten DDTC rule. And what the see-through rule states is that if you have an ITAR-controlled part or component, and it is subsequently incorporated into a larger item, doesn't matter where that incorporation takes place, whether in the United States or abroad, then that whole larger item will now become subject to the ITAR. So that is the ITAR system kind of in a nutshell.
Yeah.
I now want to move to kind of
one quick note, Aaron. Sorry. Regarding registration, I think the key, first of all, these are two ITAR quirks. They're different than the EAR, right? And the main thing regarding registration is U.S. companies that are manufacturing articles that are subject to this export control regime, even if you're not exporting the product, still have to register with GDTC as a manufacturer. And I know you mentioned that, but it's something that a lot of companies do, often come to us and ask why this is when it's an export control regime, right? And when you're, a sub to a government contractor or even a sub to a third-tier supplier, something like that. If you're manufacturing the ITAR, a part that is controlled or subject to ITAR, even though you're not exporting it, you're selling it back to the government contractor here in the United States, you still have to register. That's sort of an interesting thing.
Yeah, absolutely. It's definitely unique to the ITAR system. But we're gonna keep moving forward, and we're gonna now kind of shift gears and move to the EAR, which, if you recall from earlier, is really kind of, for a lot of people, this is the primary export control regulatory regime because it's covering a broader group of items, again, dual use items. So that obviously begs the question, what items are going to be subject to the EAR? And there are really kind of four main buckets of items. The first are items in the United States, or even those that are simply moving through transit through the United States. So for example, if an item is moving from Asia to Europe, and by sheer virtue of its transportation route, it has to traverse the United States, then suddenly it would be subject to the EAR. The second kind of big category of items, no surprise here, all US origin items, no matter where in the world they're located. The third is actually this bullet point refers to what's called the de minimis rules. And effectively what this states is that all foreign origin items, no matter where in the world they are, when they're made with more than a de minimis amount, more than a minimal amount of controlled US origin content, then they too can be subject to the EAR. There are a few different thresholds. The two most common, though, are the 10% threshold and the 25% threshold, hence why they're sometimes referred to as the 10% rule and the 25% rule. Now, 10%, to be clear, is a super low bar. To say that an item, a foreign item, is made of 10% or more of US origin content. So this 10% rule is really kind of an extension of US export controls on items made in countries that the United States has we'll say some issues with, to put it mildly. Cuba, North Korea, Iran, Syria. The 25% rule kind of in general really applies to all other kind of countries. So again, that would be 25% or more of the content. If it is US origin control of US origin and it's controlled, then it would be subject to the EAR. The fourth kind of category of items that are going to fall within the scope of the EAR are foreign origin products, but they're the direct result of US origin technology or software, no matter where they're located. And this fourth bullet point really refers to what's called the Foreign Direct Product Rules, or the FDP rules in the EAR. That is what is subject to the EAR. Its classification system is a lot different, though, than the USML in the ITAR. In the EAR, what you would do is you would try and find your item. Not all items are going to be listed, but a significant number of items are listed in the Commerce Control List, the CCL. And items are classified according to this alphanumeric code called an Export Control Classification Number, or an ECCN. I'm sure at this point you're realizing there is a lot of alphabet soup here with US export controls, but just bear with me. When you do look at this alphanumeric code, it can be a pretty lengthy sequence of digits, numbers, and letters. But to provide some sort of kind of clarification here, the first digit refers to that item's category, and the second digit, the first letter, is going to refer to an item's product group. Now, as I mentioned earlier, not every item does appear on the CCL, but that doesn't necessarily mean it's no longer subject to the EAR. On the contrary, it still is. However, if it's not captured on the CCL, then it is instead going to be designated as EAR 99. And in general, these are low-level technology consumer goods. And as a result, they're not really the primary focus of these regulatory agencies when it comes to controlling certain exports for national security interests and foreign policy priorities. Now, that being said, you might not find your item on the CCL. You might think it should be designated EAR 99, but you might not be entirely confident if that's the case. So naturally, I think that begs the question then, well, where exactly do I get an ECCN? And there are three primary ways. The first is asking the manufacturer. It might be listed on their website. If you have the relationship, of course, you could just simply ask the manufacturer directly. Sometimes you could ask the supplier when it's reasonable to do so under the circumstances. And then the third is you can actually ask BIS directly via a classification request. This is pretty comparable to asking DDTC to classify your item through a commodity jurisdiction request. So those are the three main ways. Actually, I would be remiss not to mention that at Thompson Hine, we here submit a lot of classification requests. We are incredibly familiar with this process too. So again, I guess technically there's a fourth way, and we'd be more than happy to assist. All right, so let's go back to our definition. And let's continue to break it down. We talked about the laws and regulations. We talked about what items are going to be covered under export controls. Now let's get to kind of the actual activities that export controls are focused on. That would be the export, re-export, and transfer of goods. Now, I just want to be clear. I recognize a lot of you out there probably know what these are already, but they do trip up a lot of people, not just beginners. So a good refresher can be helpful. So just bear with me. And let's start with an export. An export, to be clear, is a shipment or transmission of goods, software, or technology outside the United States, even temporarily. And a common misconception about exports is that they must be pursuant to a transaction. But that's actually not always the case. So for example, sending samples overseas, donations, gifts, that would constitute an export, even if there's not necessarily an exchange of currency, of money. Now, finally, I just want to kind of mention as well that in certain limited circumstances, performing a service for the benefit of a foreign national could also constitute an export. Kind of varies by whatever the governing regulations are. So just kind of keep that in mind as well. Now, one thing I want to do before turning to re-exports is I just want to actually use something on this slide to segue to the next, which is we mentioned under the second main bullet point that an export doesn't necessarily have to come from a sale. And you'll notice I've listed one concept of these deemed exports. So I just want to kind of quickly touch upon what those are. A deemed export is the release or disclosure of technology or software to a foreign national in the United States. This release could be oral, so for example, conversation over the telephone, could be visual, such as a factory tour, and it could be electronic, such as just simply sending an email. So in those situations, even though the information might not literally be leaving the United States, you could be conveying it to a foreign national, and as a result, the agencies will consider or deem it to be an export to that individual's country. So that's what a deemed export is. Now let's talk about re-exports. Re-exports are going to, of course, be comparable to exports, but there is a little twist. In an export, you're basically sending something from one place to another. With a re-export, this time, again, you're going to have an export. However, you're going to send it from one country, and from that country, from that intermediary country, it's going to continue on to yet another foreign country, to presumably its end destination. Now, I know some of you out there are probably thinking, that seems odd. I just assumed US export controls would kind of govern the movement of my goods from A to B. So this notion that somehow it's going to continue on, even perhaps extraterritorially, is unusual. And you would be right. By their very nature, re-exports reflect an extraterritorial application of US export controls. Now,
I think a good way to think about this is that with export controls, that when you mentioned earlier, what was subject to the EAR, it's U.S. products wherever located, and so the controls on the product sort of follow the product wherever it goes all over the world, and that's why the re-export idea is even if it goes from the U.S., as long as it started in the U.S. or was subject to the EAR for some other reason, right? Went to another country, it still follows it as it goes to this third country.
Yeah, absolutely. And along those lines, since we're on the subject of re-exports, when we talk about exports, we had deemed exports. So I think this also begs the question, are there such things as deemed re-exports? And yes, there are. You would be correct. It's pretty much the exact same. Again, this release or disclosure of technology or software, but this time now it is happening in a foreign country to a third country national. So they're deemed re-exports. That is kind of, a lot of people forget about them, but they do exist and you do need to be mindful of them. Now, finally, that third activity that we had highlighted in the definition was transfers. And a transfer is, it's more often, it's when there's a change in the end user, although technically it could also refer to a change in the end use of the item within that same foreign country. Now, I just want to be clear, sometimes the regulations refer to transfers in country and in country transfers, and there's really no rhyme or reason as to why they choose one or the other, but they are synonymous with each other. So don't let this trip you up. It does seemingly get a lot of beginners, but now that we know what it is, it won't get you, which is fantastic. Now, before we actually return to our definition and continue to break down our definition of what export controls are, I actually realize we've been talking a lot about these activities in the abstract. We've defined them. But you could be like me, and you're more of a visual learner, and as a result, it might be helpful to actually diagram what these activities entail. So we're going to spend the next few slides doing just that. So let's start with what an export is. An export, and I don't think this is really going to come as a surprise to anyone, is going to be the most simplistic type of activity, right? It's going to be A to B. That is an export. A in the United States to B, a national of country X. There's your export. Now, what about deemed exports? Now, let's say that B moves to the United States without relinquishing their nationality. I don't know, maybe B got married, they got a new job, whatever reason, B is in the United States. If A were to release or disclose kind of technology or software to B, then that would be a deemed export. Notice how this is all taking place inside the United States. So there's a deemed export. All right, let's let B go back home. And now let's move on to re-exports. If you recall from earlier, a re-export by its nature has to involve an intermediary country and at least one other intermediary and then the end destination. So let's bring C into the party, and C is going to be a national of country Y. So A to B, that's our export, and B to C, that right there is the re-export. And what I love about this slide is it really highlights the fact that a re-export by its nature is predicated on an earlier export. And that's why I've desaturated A for you to suggest it's always happened, it's always been lurking in the background, but ultimately B to C is the re-export. So you can have multiple kinds of activities presented by just a single export transaction. All right, let's get rid of our arrows. Let's bring A back to the party. And let's move on to deemed re-exports. So let's say that C, without relinquishing their nationality from country Y, moves to country X now, right? And we have A to B, there's our export. And then now B is going to release technology or software to C in country X. That is a deemed re-export. And again, I've desaturated A for you, and I think that really kind of hammers home what exactly we're talking about. All right, finally, let's turn to in-country transfers. Let's say goodbye to C. And an in-country transfer, again, is always going to be predicated on there being an export. So I'll desaturate A for you in just a moment. But for an in-country transfer, what we actually need to do is we need to be a little bit more specific with B. Let's call B B1, and we'll give B1 a friend. We'll call B1's friend B2. And if B1 were to then kind of maybe sell the item onward and there's a change in the end user to B2, that is an in-country transfer. Now, a lot of what we've just kind of diagrammed and discussed is predicated on this notion of nationality. So for natural persons, for individuals, human beings, a person is considered a foreign national differently depending on the regulatory regime you're looking at. Under the ITAR, it's incredibly more inclusive. It's all countries in which the foreign person has held or holds citizenship or permanent residency. That is very different from the EAR, which only cares about the most recent country of citizenship or permanent residency. Now, even though this is how the regulatory regimes define these terms of what a foreign national is, I should point out, we can actually take this information and deduce that the inverse is true as well. In other words, what a foreign national is not. Therefore, a foreign national is not a US citizen. It is not a lawful permanent resident, what we refer to as green card holders here in the United States. And finally, it is not a certain statutorily protected individual. So that's what that's kind of how nationality factors into US export controls. All right, let's return to our definition. We're going to continue to break this down, and where we left off was how exports are going to be regulated based on the end destination. And actually, this brings us really to our third question in our chain of 7 questions, if you recall from earlier, which is where are you exporting? And what you're going to do is, if you find that item on the CCL and you see it's classified with an ECCN, you're then going to take that information and you're going to cross-reference it with the Commerce Country Chart. And to be clear, what you're seeing on the screen very much is a screenshot of the cover page of the Commerce Country Chart, the CCC. Again, more alphabet soup. As you can see, the rows are going to be filtered according to the end destinations. And what you want to do is you want to see if your item is controlled, if there's a reason for control. And that's indicated by cross-referencing the corresponding column and seeing if there's an X, okay? And if there's an X, there's a reason. If there's no X, there's no reason for control. And as you can see, there are 8 reasons for control. I've identified half of them on the screen. And these are admittedly pretty broad, right? National security, regional stability. And just be mindful of the fact that this is really based on what BIS thinks is a valuable and important reason for controlling an item. not what you might think. So, you might think that your item isn't necessarily going to destabilize a region, but BIS might disagree with you. So you definitely kind of want to make sure that you're kind of approaching this broadly and perhaps from the perspective of the government, and be careful as you send something abroad. Now, I think when you talk about end destinations, naturally this begs the question, well, are there just simply places I cannot transact with or deal with? And the answer is yes. The United States maintains comprehensive sanctions, or colloquially what we refer to as an embargo, against 4 countries: Cuba, Iran, North Korea, and Syria. And perhaps unsurprising due to current events, also 3 eastern regions of Ukraine: Crimea, Donetsk, and Luhansk. Now, I can't stress enough how we're talking about places, not countries. So you do kind of need to be a little bit flexible in your approach here. You can't necessarily think I'm sending it to a particular country and therefore that country is the focus of my analysis. You do kind of need to be a little bit, flexible in how you're approaching this. But I do want to point out that there's still other places, while they might not be outright prohibited to transact with, they still, provide significant restrictions and limitations. And as you can see, I've identified just a handful of them, and they should be appearing on the screen. I don't think any of these places are particularly surprising: Belarus, China, Russia, Venezuela, right? So, just always bear this in mind when you're looking at where you're going to send your item. Now, returning to our definition, we just continue on. We'll go to the end user, restrictions. Now, every party to a transaction has to be checked, or as we'd say in the business, has to be screened in your due diligence, not simply the ultimate end user. So another way of asking this question is, who will receive the export? Sure, the ultimate end user will be the final recipient in that chain, but they're not necessarily going to be the only party that is going to receive the item. And this is a great way to incorporate this foreign nationality concept that we introduced earlier in your screening. So to keep things simple, I'm just going to bring back one of our diagrams. We'll look at a basic export, and we have A to B, right? We talked about that earlier. But let's say that rather than selling directly to B, A actually decides to send the item through a third party that we'll call D, like distributor D, right? In that instance, then you would absolutely want to screen not just B, but also D in your transaction.
And this sort of, if I can jump in here, Aaron, this kind of basically anticipating a question here that we would probably get from that we do get from clients that we work with pretty frequently. This idea of screening the ultimate end user as well, especially when you're using a third party like a distributor or an agent, right? Where you may not have access, particularly in the distribution model, you may not have access to the information about the ultimate end user, right? And so you're screening the distributor, but really, where do we stop? How far do we have to go in terms of screening and diligence? And it's interesting because this question comes up often, and basically what we try to do is just as much due diligence as possible. We understand that distributors likely are holding that information about the end user close to them because they don't want you going around them and then just selling directly to the end user. They control sort of that aspect of it. And so a lot of it does come down to your relationship with your distributors, teaching them about export controls and making sure that they're doing the diligence onwards about the end users that they're selling to. And then also sort of the contractual obligations, putting it in the contract that they are required to screen or perhaps provide end user certifications, or even putting the full risk on them, saying that if there are violations, perhaps the U.S. government will come after A in this diagram because we are the ultimate principal, and under a principal agency theory, you go after the principal. But maybe you have a private cause of action against the distributor should the distributor create a situation where A is in trouble. There's a lot of ways to think about this. And we do get that question pretty frequently about how much diligence, where do we have to go? Do we have to go to the next level? How many levels down the chain do we have to go? This is going to come up even in later presentations, I'm sure, regarding supply chain and suppliers. But this type of thing comes up in export controls as well.
Yeah, absolutely. And of course, I think a lot of people are wondering, based on what we're discussing, well, where exactly do I go to screen a person? And just to be clear, when we use the word person, we're using it in the legal sense, right? Legally, a person could be a natural person, like a human being. We talked about that earlier, but it could also be a legal person, a business organization. So it's when we say person, we're not just kind of using it the way that we casually throw out that word. And what you would do is you would screen that person's name against a prescribed party list. These are there are a wide variety of lists maintained by the U.S. government, and they kind of espouse certain restrictions or outright deny certain persons. And this is not a comprehensive list by any means. I've only highlighted a handful on the screen, but there is one in particular I do want to highlight for you, and that is the specially designated nationals and blocked persons list, the SDN list maintained by the Office of Foreign Assets Control, OFAC, within the Department of the Treasury. This is an example, as we noted earlier in this presentation, where economic sanctions kind of has a little bit of overlap with export controls and therefore causes confusion. But I just kind of wanted to quickly highlight that for you. But that being said, we are going to move back to our definition, and we're going to proceed onward to the final clause, which is the end use of the item. This is going to bring us to our fifth question in our chain of 7 questions. And basically what this is all about is that under US export controls, items can be prohibited or restricted depending on their end uses. I've identified just a handful of them on the screen, but candidly, I don't think any of these are going to be super surprising. So to highlight one in particular, chemical and biological weapons, right? If you really think about it, the United States absolutely has a national security interest, let alone a foreign policy priority to be cognizant of making sure that certain individuals in certain areas of the world don't gain access to chemical and biological weapons. So you do need to be mindful of this when you are kind of asking yourself, can I export this item? Now, let's return to our definition. And for my eagle-eyed viewers out there, you probably noticed this entire time I have been actually jumping over one little clause in particular, and that is the rules. Now, specifically, when I say the rules, I'm really kind of using that as a shorthand to the last 2 questions in this chain of 7 questions. So do you need a license, and what are the management requirements? So let's tackle this. We'll start with question 6. Do you need a license? Okay. Now, sometimes the answer is just flat out, no, you don't. So for example, if you have an item and it is designated EAR 99, meaning it did not appear on the CCL, then you can send it overseas under the designation NLR, no license required. Now, similarly, there are plenty of items that do have ECCNs that do therefore appear on the CCL, but if you, in that cross-referencing exercise with the commerce country chart, don't see an X in a cell, then it's not going to be controlled given the destined country that it's going to, and it too can be sent overseas under the NLR designation. And as a matter of fact, the truth is that most exports from the United States don't actually require a license and therefore can be sent overseas under no license required designation. Now, sometimes when you look at an item, you might say, well, actually, I do need a license, but there could be a license exception that I can invoke, that I can avail myself of to therefore not have to procure one. And as you can see on the screen, there are 22 license exceptions listed in the EAR. And I think that this is a really fun slide because if you attended this session last year, then you would have noticed that there were 18 license exceptions, which means we have 4 brand new ones in the past year alone, which I've identified for you. And this is, I really enjoy this because what this signifies is that export controls are dynamic. These regulatory agencies are constantly changing, amending, adding components and aspects to their regulations, which of course keeps life interesting, right? It's a little bit of a trick to deal with, but it does kind of really, I think, convey how dynamic this is and how you really need to keep your eye on the ball when you are dealing with U.S. export controls. Now, I should point out that there is still a follow-up consideration to all of this, which is you might either have an item that does not seemingly require a license, or you believe that you can invoke one of these license exceptions and therefore don't need such authorization from BIS. However, you might still be sending that EIR item, controlled item, to a certain end destination, end user, and end use that is either restricted in some manner. So what we always kind of advise clients is, even if you think that you don't need a license, we always say, rather be safe than sorry, double check. Please double check. It is super, super important to get that right. No one wants to violate US export controls. Now, and by the way, if you are successful in obtaining a license, you apply for one and you get one, they generally have a 4-year validity period. Now, if you do, go through all these steps, the last kind of thing that you need to think about is what are kind of the continuing management requirements. And the regulatory agencies love it when companies have compliance programs, and especially those that are audited. In fact, I purposely use the word audit on the screen because after this presentation, when you print out the slide deck and review it, I want you to remember that word audit. These agencies love it, audits in particular, because they can really highlight, either deficiencies that need to be kind of clarified or maintained, addressed. They also kind of help identify how compliance programs need to be updated and perhaps enhanced. So audits are awesome. There are record keeping requirements. And I also wanted to kind of highlight that there are other regulations as well that you would need to comply with when you talk about sending something overseas. It's not just simply the export control regulations. So one that I highlight in particular is the foreign trade regulations, which are administered and enforced by the Census Bureau. So they're not just counting people once every 10 years. It's a very active agency, and you very actively need to comply with their regulations too. I do, however, want to highlight the record-keeping requirements in particular. And fortunately, under the ITAR and the EAR, the record-keeping requirement is the same. You must retain records for 5 years from the date of the transaction and/or the relevant activity. Some of you out there are probably thinking, well, what is a relevant activity? And the answer to that is maybe you've already formalized the transaction, but you still need a license. So securing that license, that would be a type of relevant activity. Now, naturally, I think this question, when you talk about record keeping, the immediate question that comes to mind is, what are these records that I need to maintain? And to that, we'd say it's pretty much all types of documentation related to the export, right? Invoices, purchase orders, license requirement determinations. And the reason why you would want to retain these documents is really twofold. One is, of course, doing so demonstrates good faith compliance with US export controls, which is fantastic. But the other reason is that if there is wrongdoing, or if you're accused of wrongdoing, then going back in your records can help you not only identify perhaps what went wrong or what seemingly went wrong, but it can also help you formulate defenses. So it's always a good kind of reason to kind of keep all of these documents on file for the 5-year period. Now, I also just want to move on now to red flags. Red flags are, a constant source of concern because there are a whole bunch of them, as we'll see. But I want to point out that US law actually requires you to check for red flags. And in fact, if you don't, you can still be held liable for not checking. So you can't just simply, adopt this willfully blind approach. Now, the bad news is, unfortunately, there is no comprehensive list of red flags online. However, BIS does have a significantly lengthy list of red flags listed online. I've actually provided the website for you to go check out after this presentation, and that can really help filter your lens as you try and determine, as you try and analyze one of your exports and see if any red flags pop up. I do want to highlight actually just a few because I think that can be a really helpful exercise. So for example, these are some common red flags. So if you have an end user or its address is identical or similar to that of a prescribed party, for sure you need to look into that. And when I say you need to look into that, what I'm really trying to emphasize here is that red flags are not necessarily fatal to your export transaction. They just simply require additional scrutiny, right? They could be fatal to your transaction, but not necessarily and probably not initially. Another common red flag that we see is if an end user has no business background or doesn't typically engage in business consistent with the exported item. So to use an extreme example, that would be like a company in a country that is, in a very dry, maybe hot, arid, desert-like climate, and suddenly they are importing a whole bunch of snowmobiles, right? As an exporter, you would certainly, I think that would raise eyebrows. It's not fatal to the transaction. It could be something very kind of not worth, not super scary or foreboding, but it certainly would raise eyebrows and therefore warrant additional consideration. Another common red flag that we see is if an end user is significantly overpaying for the item given known market rates. A fourth is when a freight forwarding firm, by its nature an intermediary party, is listed as the product's end user. Again, this could just be simply a clerical error, nothing more, nothing less. So it's a red flag, you still need to check for it. And then finally, another common one that we see is when there are abnormal shipping routes given the item or the end destination. The concern here is transshipment. And I should point out that the United States government actually has a really wonderful list of transshipment points and ports online. So it's something to check out after this presentation. There is one red flag in particular that I really want to highlight for you today, though, and that is this notion of diversion risk. This is a top concern among US export compliant officials. And effectively what this refers to is the illegal practice where you send an item to a seemingly legitimate customer, but in turn, that customer then resells the item to a prohibited end destination, end user, or for a prohibited end use. That's obviously highly unfortunate. And I really can't emphasize enough, though, that you have to look for diversion. And in fact, all of these red flags, you can't just simply take this as this, the infamous head in the sand approach. It just simply won't fly. You could still be held liable for illegal diversion. So while we are on the topic of fear, we're going to move on to penalties. Keeps a lot of people up at night. And let's start with the financial penalties, and then we'll move on to the administrative penalties. So we'll start with the ITAR. I should point out the ITAR's civil violation, as we'll see momentarily with the EAR penalties, are going to be adjusted annually for inflation. The ITAR civil penalty, though, is particularly painful. You could be hit with a civil fine of up to $1.2 million or twice the value of the transaction, whichever is greater, per violation. Not per export, per violation. The criminal violations are also, rest assured, just as painful. There could be a criminal fine levied by DTTC in the amount of $1 million per violation. And for my natural persons, which we now know what that is, who can very much go to jail, unlike businesses, you could be facing a 20-year imprisonment sentence. Now, under the EAR, the financial penalties are structured pretty similarly. This time, the civil violation is going to be just shy of $365,000. That's a near $12,000 jump from last year, by the way. Again, that's going to be per violation, not per export. And the criminal violations are actually identical. It's going to be $1 million criminal fine per violation, or 20 years in prison. Now, these are very painful, but they are not the only penalties at the regulatory agency's disposal. One thing I cannot emphasize enough, and it should be a major takeaway from this presentation, is that in the United States, exporting is a privilege, not a right. And as a result, the regulatory agencies can actually deny you of that privilege either permanently or temporarily, or generally, or to a certain particular subclass of items. So that is one penalty. Another type of administrative penalty is the seizure and forfeiture of goods and vessels. A third is the exclusion from practice. What effectively that means is if you're an attorney or an accountant, if you have some type of business before an export control regulatory agency, like applying for a license, or maybe you already have a license, or other type of business, then you can be barred from doing so. And that would really tarnish your ability not only to practice, but to assist people complying with US export controls. So that's a very painful one. Another one would be the suspension of government contracts. And then finally, there are two types of other administrative sanctions. They're weirdly called protective administrative sanctions, but rest assured, they're just as painful as the other penalties. The first is that you could be denied invoking certain license exceptions that other exporters could otherwise invoke and avail themselves of. And then finally, if you do have a license, then that license could be revised, suspended, or revoked. Now, I don't really want to leave you guys on this kind of note of fear, so let's move to recent trends. I just want to point out, if you attended this session last year, you would have noticed that one of the trends that we saw was heftier fines. BIS levied its largest standalone fine in its administrative history. And this time around, this past year, it was DDTC's turn. So you can imagine how we all reacted in March when DDTC issued its largest standalone penalty in over a decade. And then our jaws just hit the floor literally just a few weeks ago in September when DDTC issued its largest standalone civil penalty at $200 million. So incredibly painful. Also last month, there was a final rule kind of really codifying certain policy memoranda related to the voluntary self-disclosure process. It also kind of updated the BIS penalty guidelines, effectively giving the agency greater discretion in its enforcement proceedings. So that was another kind of major development. And then finally, this past calendar year, we've seen a lot of moments when the agencies have really been engaging with the exporting community to really promote US export controls, what they are, and how they should be complied. So the theme last year, if you recall, was enforcement, enforcement, enforcement. If I had to change it this year, I'd say it would be enforcement, enforcement, and education of that enforcement. So with that, if we have time, we can entertain your questions. But before we go, I just want to also note that here at Thompson Hine, we have a blog dedicated exclusively to international trade law. So if you're not already, we highly encourage you to subscribe. And as a result, you can really learn about what is happening on a day-to-day basis, the latest news and alerts in international trade law. So thank you so much for your time. And Samir, I'll turn it over to you and ask, do we have any questions? We have time. And
Yeah,
thank you
in
all.
the interest of time. Yeah, thanks, Aaron. In the interest of time, we'll just get back to the questions individually. But thank you all. Thanks, Aaron. Thank you all for your interest in attending today's webinar. We will be having 3 more of these SmarTrade Fundamentals webinars once every 2 weeks, starting 2 weeks from now with imports and customs. Please log in. Thanks again. And if you have any additional questions, please reach out. Have a great rest of your day.
Thank you, everyone.